Okay, here we are. I am joined by Dan Ray again. Uh, Both of us have studied the Constitution for many years, and we're talking about a big day and a pretty big term, kind of a consequential term. Dan, we have been watching the Supreme Court as the Supreme Court said that Title VII of the civil rights laws protects people on the basis of sexual orientation or transgender status. We watched as the court sort of admonished the Trump administration or scolded the Trump administration for its sloppy, shoddy work on trying to get rid of DACA. And today, I think, was another jolt for people who expected that once Donald Trump had two appointments to the Supreme Court, right, that Roe versus Wade would be history. So you and I wanted to make three big points that I'll throw to you each one for your thoughts. But the first big point I think that needs to be made, and we're talking here about the case that was released just this morning, the opinion that was released, striking down a Louisiana law that required admitting privileges for doctors performing abortions in Louisiana, that would have reduced the number of clinics in Louisiana to probably one, if not none. And again, as far as conservatives thought, they've got the 5 votes now, right? Because Roberts never thought Roe versus Wade was properly decided, and neither did the other 4 conservatives. Certainly Kavanaugh replacing Kennedy, right? That was it, right? Once Kavanaugh replaced Kennedy, you have the 5 votes of justices who don't think that abortion is a fundamental right, a fundamental liberty interest. So they were probably expecting a different result. So that's the case we're talking about, the case out of Louisiana on abortion, in which Justice Roberts sided with the 4 liberals to strike down Louisiana's law. So first big point. It seems, Dan, that as long as Chief Justice Roberts is calling the shots, this court, right? And again, this is not going to be good news for some people. This court is not going to overrule Roe versus Wade. So the more specific question I would ask you to discuss is the talks that you and I have had over the years about Justice Roberts being an incrementalist and an institutionalist, at least to some extent.
Yes.
And that seems to have overcome ideology in this particular case.
I agree, and it's this is an important point. It explains, I think, a lot about Chief Justice Roberts generally, and a lot about Chief Justice Roberts when it comes to abortion decisions. Simply remember the 2 I's: John Roberts, the incrementalist, and John Roberts as Chief Justice, the institutionalist. As to the former point, John Roberts, the incrementalist, he made his views on how to deal with Roe versus Wade very clear at a very early stage in his career. When he was working for the Justice Department as a very young lawyer, he wrote what is now a rather infamous memorandum saying the way to deal with Roe against Wade is not simply to try to overturn it wholesale. There are far too many problems with that, particularly political problems with that. The way to deal with Roe versus Wade, he argued, was in a piecemeal, incremental approach. You don't try to just knock it off the books entirely. With a series of decisions, instead, you sort of hollow it out from the inside. You water it down to the point where there is little or nothing meaningful left of the right to terminate a pregnancy. So it seems clear that that's the approach he has taken, not only during his career as a practicing lawyer, but since he arrived on the bench. So I think that in large part, this incremental approach, it reveals a lot about why he has voted the way he has in this particular case. But don't forget the second I as well. Chief Justice Roberts, the institutionalist. Part of the role of a Chief Justice is to protect the institutional strength and the institutional standing of the United States Supreme Court as the, or more generally, Article III courts as the third branch of our government. That means from time to time that he needs to think not so much doctrinally and not so much from a personal outcome preference standpoint, but from the standpoint of what's the best thing for the court as a whole. Under these circumstances, and you and I have talked about this, Brendan, many, many times, under these circumstances, I think it's fairly clear that the Chief Justice is sensitive to what's going on in the larger world around us, and in particular, politically speaking. There's an awful lot happening in the world, and much of it is not good for the Republican Party. If the court was to take a drastic step, like cutting the abortion right off at the knees, so to speak, in this particular case that was handed down today, it could have significant political consequences, none of which Chief Justice Roberts wants to bring about.
And also the sense of, and we talked about this earlier as well. And you know, I don't think this is too political to talk about this. I think that does play into it. But he's watching an executive branch, and again, I'm sure people will be offended about this, but from any objective standpoint, that is going off the rails by historical standards.
Clearly.
Yeah, we've never seen anything like this going on in the White House. So yet you have that in the middle of a pandemic and in the middle of social unrest, racial issues. So you also have Congress failing to engage in any oversight and usually deadlocked, and failing to jealously guard its own role in our tripart government.
Right.
So I wonder sometimes if John Roberts, you know, doesn't just look around and say the Article III branch of government is the only one that's still on the rails.
There you go.
Yeah.
Very clearly, yes. And another sort of corollary point that you and I have talked about many times is, I think it's a fair question to ask what the Republican Party really thinks about overturning the Roe/Casey line of decisions. It's, I think, too plain to really even argue that a wholesale change in individual rights like that would virtually hand the levers of federal power to the Democrats for a long time to come. That's an issue that Republicans for decades have campaigned on, have raised funds on, and have made significant political gains on. And Republicans who are thinking down the road and thinking strategically may very well say to themselves, in the privacy of their own homes, do we really want to take a step like this and get rid of Roe and Casey? And a lot of them, I think, in their heart of hearts, say the answer to that question is simply no, we don't. Right.
Of course, then there are your true believers who have to be absolutely furious.
Of course.
They started losing their minds with the Affordable Care Act case, Sebelius, when Justice Roberts voted to uphold the Affordable Care Act, and this term hasn't done anything to endear him with that group, that's for sure.
Clearly, yes.
That, I suppose, leads us into the second big point out of the case, which is, you know, last week I did a radio interview where I said, you know, we're going to see really a competition between John Roberts, the institutionalist, and John Roberts and his actual beliefs, because he voted in a case almost identical to this one, which you and I know is called Whole Woman's Health versus Hellerstedt, to uphold a Texas law that is in all respects indistinguishable from the law that he just voted to strike down. So he was either going to vote consistently with his own judicial philosophy or ideology, whatever you want to call it. He was either going to vote the same way he voted in the Hellerstedt case. What's happened is that As I mentioned at the beginning, Justice Kennedy is no longer there and it's been replaced by Justice Kavanaugh. So Roberts didn't have Kennedy to bail him out, right? Right. And save him from overruling Roe versus Wade if he didn't really want to. So he's lost his freedom to vote in a way that is purely ideological because of the institutionalist role that he plays. So he was either going to vote the same way he voted and stay true to his own judicial philosophy, I'll just call it that, or he was going to vote with the liberals this time, not consistent with his vote in Hellerstedt in a philosophical way, but rest his decision on stare decisis, right? That's the second big.
Yes.
You know, the Hellerstedt case, I did the math, was only 4 years ago, and to overrule for the Supreme Court to overrule itself 4 years after a decision like that, based only on a change on the court, right, from one justice to another. That's the only thing that's changed. There's been no social, right, big social change or anything like that going on. I was always amused at the, how Justice Scalia blew a gasket. Remember when the Supreme Court overruled Bowers versus Hardwick only 17 years after deciding that case, and said, you can't do that. You can't overrule an opinion that's only 17 years old. So imagine 4 years, right? Right. Really would have been called into question the credibility of the court and its role in our society. The third thing, and this is a little bit nuanced, but I think it's extremely important for people to understand is, okay, so he voted with the 4 liberals, but the way the abortion test works, and what I mean by that is the legal framework that the court uses to analyze abortion cases, is it applies something called an undue burden standard, which under Casey was defined as, we keep talking about these cases, there are really 3 huge ones up until today, right? Roe versus Wade, the Casey versus Planned Parenthood of Pennsylvania, and then Whole Woman's Health versus Hellerstedt. Roe established the right, but Casey sort of gave us a legal framework, as to the extent it really is a legal framework. It gets a little bit valuable, but Casey says, okay, the state does have some role in regulating medical procedures the way it regulates regulating abortion procedures the way it regulates any medical procedure. It does have some role in protecting "quote unquote" potential life of the unborn, and so it's not that the state can't place any limits at all on the right of a woman to terminate a pregnancy. It's that the state can't place an undue burden on the right, and that is defined as a substantial obstacle placed in the path of a woman who wants to terminate a pregnancy. So that, substantial obstacle, that's a test that if you're a conservative justice, you can use and say, well, it's an obstacle, but it's not a substantial obstacle. Right?
Very malleable. Very malleable.
Yeah.
One size fits all.
Right. Then in Hellerstedt, okay, in Whole Woman's Health versus Hellerstedt, the court, with Kennedy going along with the liberals, sort of massaged that legal framework and made it into what the court called a balancing test, where now to decide whether a burden is an undue burden, we simply weigh the burden on a woman's right to have an abortion, right? What's the burden and what is the benefit? And the courts there seem to be talking about benefit as far as medical outcomes, right? Is there some kind of benefit here? Under this balancing test, in my mind, and we talked about this earlier as well, in my mind, if you are challenging an abortion restriction, it is easier for you to do that under the balancing test, because now I don't have to get into all this, whether the obstacle, how big is it? Is it as big as a mountain, or is it, instead, to win, all I have to say is, well, the burden outweighs the benefit. There's really no medical benefit here, and it places some burden on a woman. Therefore, it's unconstitutional. Justice Roberts, and that was very long-winded, but I think it's kind of necessary backdrop for what happened next. Right?
Yes, correct.
Justice Roberts, when he said, I'm sticking to the stare decisis rule here, said, what I mean by stare decisis is that I'm sticking to the substantial obstacle, right? Because he was saying that the court had no reasoned justification for moving from Casey's substantial obstacle test to some kind of even easier, right, on the challenger balancing test. So he says, when I say that I'm hewing to our precedents, what I mean is I'm hewing to the standard that was enunciated in Casey, and I'm applying the substantial obstacle test. So this is big because now there are only 4 justices instead of 5 on the Supreme Court who would use the balancing test.
Correct. And to sort of put a bow around all this, I don't think there's a whole lot more that I can say that adds to what you just said, but to sort of put a bow around all of it, if you will, what we're saying here is that in Whole Women's Health, the court began with, again, Justice Kennedy's vote. The court sort of took a step towards liberalizing, if you will, the abortion right, making it easier for women to obtain an abortion, making it harder for states to restrict that right. This is the Chief Justice's attempt to sort of yank the scale back in the other direction, back towards Casey, back towards the undue burden substantial obstacle test, which places a higher burden on those who are challenging an abortion regulation, makes it easier for the states to restrict the abortion right. So what we're seeing here, again, and we've talked about this, is the incremental tug of war back and forth, not at the margins or at the extremes of the abortion right. Is there going to be a Roe/Casey or not? We're not in that territory. We're arguing over some fairly nuanced and subtle things here, but this is the way that the abortion right, I think, is going to be fought over in cases that come, unless, and we can't discount this possibility too, there is a change in the composition of the Supreme Court. If one of the 4 liberals ends up leaving the court, whether by death, disability, or retirement, and is replaced by another Trump appointee, or for that matter, any other GOP appointee, then we could be, again, changing the tenor of the conversation substantially.
Right. What, explain, if you would, the legal effect of a plurality opinion, and how important it is to understand that. We have a plurality opinion here authored by Justice Breyer on behalf of 4 justices.
Correct.
And Justice Roberts concurred, but did not concur in their use of the balancing test. So what's the significance of a plurality opinion like that?
Well, you know, this is some somewhat technical stuff, but a majority opinion is what you shoot for, right? You want at least 5 justices or more, because then it's not one of those narrow, evenly divided decisions. But in a case like this, where the issue is so hotly contested on both the left and the right, we've got a decision by the 4 liberals written by Justice Breyer, that 4 justice opinion is called a plurality opinion, because in this case, Chief Justice Roberts concurred in the judgment or the outcome only. That's basically him saying, I disagree with the reasoning that the plurality, the 4 justices used to get to their outcome, but I agree with the ultimate outcome. I agree with the outcome only, not with the reasoning that was used to get to that outcome. So in a plurality decision like this, then one of the important questions that emerges is, what's the controlling opinion? What's the controlling decision in a plurality case like this? And the answer is, it's the narrowest opinion that gets to the outcome that has 5 or more votes. So that becomes the question in this case. What is the narrowest opinion, the narrowest decision that gets to the 5-justice outcome here. And arguably, I think most likely, that narrowest opinion is the Chief Justice's stare decisis opinion. He says, I'm not changing any doctrine. I'm not changing any of the controlling law. I'm just saying we're going to let things stay where they are now for the time being. That's a very narrow, very tailored decision. That's probably the controlling opinion in this case. Do you agree?
Yeah, that was very well explained, and I do agree. I also think that he made it clear, to repeat myself, that the balancing test. So when you talk about the narrowest way to reach the decision, I think the way he married stare decisis with the old substantial obstacle test, and said, if I'm following Casey's obstacle test, I have to say this is a substantial obstacle.
Yes, correct.
So I think you're right. I think that when you look at plurality, the 4 justices and then the 5, when you add Roberts' opinion is the one to read. That's the one, I think, that really sets the legal framework for future cases.
Clearly so, yes. If you've only got 10 minutes to study this case and you don't want to read the plurality opinion, read Roberts' concurrence. And I think you know pretty much what you need to know about the current state of constitutional abortion law in this country.
Right. Now this brings us to maybe, I don't know, I think sort of one of the more interesting questions in this case. Yeah, and it has to do with the plurality majority thing.
Yes.
When the Chief Justice is in the majority, which he was, right? I mean, he has the privilege of assigning who writes the opinion. So he'll either assign it to him, write it himself, or he'll decide who writes it. So one of the real interesting questions we discussed earlier, and I'll ask you to opine on this, was why, if Roberts was in the majority, was part of the 5 in this case, why would he have assigned, or would he have assigned, writing that opinion to Justice Breyer, of all people, who was going to write a plurality opinion that Roberts disagrees with, at least in terms of its use of this balancing test?
Fantastic question. And again, this is Supreme Court Politics 101. We will never, or not never, we may at some point, but it'll be way down the road. We may know the answer to this question when many or most of the justices currently sitting are off the court and some memoirs get published.
Right.
But until then, all we can do is speculate. So the question is, as you say, why would Breyer be the one who writes an opinion that the Chief Justice has to concur in, but doctrinally he so strongly disagrees with? And the answer that seems to be emerging from people who study the Supreme Court is Roberts started out on the other side of this case. He started out with the conservative 4 justices, and it was going to be a 5-4 decision that maybe struck whole women's health and maybe did even more substantial damage to the abortion right. And so there was probably this harkens back to the Planned Parenthood against Casey decision, many now going on nearly 3 decades ago, where for a brief period of time in this country's history, there were 5 votes to overrule Roe against Wade. And Justice Kennedy was one of those 5 votes until he was ultimately persuaded to flip. And that's how we end up with the Planned Parenthood against Casey decision that we all know today. So it was much like, or at least somewhat like, that particular state of affairs on the court at some point during the pendency of this case. But then, for reasons unknown, the Chief Justice flipped. He now becomes the justice that is joining the 4 liberals. So because he's the Chief Justice and is deemed to be the senior justice on whatever side he's on, how does it end up that Breyer writes the opinion? And the answer is Breyer's opinion was probably going to be the dissenting opinion in this case. When Roberts flips, he doesn't want to take the opinion away from someone who's already started to write it. So rather than take the opinion from Breyer and write it himself, He simply decided to let Breyer go ahead and write, and then write a very narrow, tailored, conservative, if you will, concurring opinion that gets to the 5 votes, but doesn't join the doctrinal outcome, if you will.
Right. Yep. And like you say, we're taking a guess here, but that's the kind of thing that really kind of strikes you is, and it absolutely struck me. My first reaction when I, well, first of all, heard about the outcome of the case and then pulled it up and looked at it was I looked at the author, Breyer, of the plurality opinion and asked myself, wow, how did Breyer get the Chief Justice to agree with him? And not only that, but appoint him as the author of the case. And then you find out that Roberts didn't join that opinion, that he wrote a concurring opinion. Something happened.
Yes. There is no way in a decision of this kind where Chief Justice Roberts starts out as part of the 5, that Justice Breyer writes this opinion. That ain't happening. It would be more likely that you or I would write the opinion than Justice Breyer would write that opinion. It ain't happening.
Yep. So maybe we're wrong, but I think we're right. At any rate,
it's fun to speculate.
Yeah, it is. And it wouldn't be the first time that Roberts has done that, by the way. He did that in the Affordable Care Act case.
Exactly correct. Yes, exactly so.
Okay, so I think we've made our 3 big points coming out of this case. Number 1, the abortion right is not going to be overruled as long as Roberts is calling the shots. Okay, as you said, it'll be chipped away, but not Roe versus Wade is not wholesale going to be overruled. Number 2, the hook that the Chief Justice hung his hat on was stare decisis. And number 3, it's pretty clear that even though the liberals, quote unquote, have won the day in this case, the test, the legal framework that the court uses is moving back to a place where conservatives are going to be a little more comfortable with it. Would you agree with all this?
The abortion right, to sort of, again, put a bow around it, the abortion right survives. It is still, regretfully, on somewhat shaky ground. Mm-hmm. So stay tuned. This battle is far from over.
I was gonna call it over right there, but I'll one more point, right? If Donald Trump gets reelected, the abortion right is gone. There is absolutely no way it survives a second term of Donald Trump. So if you're, depending what side you're on this, right, that's critical because we have Breyer and Ginsburg, and I don't mean to sound like the Grim Reaper here, but the chance of those two still being on the court after another 4 years is slim to none. And if they're replaced by Donald Trump appointees, 2 more Kavanaughs, well, we know what that's going to mean. So people have to keep that in mind. I always hear people, oh, who cares who wins the election? It doesn't make any difference in my life. Watch the Supreme, right? This election matters.
And that's one of the points, by the way, that the GOP is very good at driving home. One of the things that the GOP has been very, very successful with politically is moving people to the polls in order to control the presidency and the Senate so that they can then obtain control of the Article III courts. So this is not something to sort of just blow off and ignore. This is an important political point.
Excellent. Great conversation. Thanks as always. Yeah. And we'll be back. You know, there's more big cases coming down the pipeline here, so we'll be back to talk about those.
See you soon.